Good morning. Welcome to our May administrative public hearing. We're glad you're here and eager to hear from you on the items on our agenda. Our typical way of going about this is every speaker gets 3 minutes. Your lights will tell you how that 3 minutes is going. Of course, if we have more questions, you may be up here longer than that, but that's the way we will proceed. And we'll get started with the first item, which is the proposed amendment to MCR 1.109 and the corresponding administrative order regarding the process for exemption from e-filing and whether to adopt the new proposed administrative order. And we'll start with Kim Kramer from Michigan Legal Help.
Good morning, Justices. Thank you for giving me the opportunity to comment this morning. In my 3 minutes, I'm going to try to cover 3 elements of the rule and proposed administrative order: the exemption standard, the placement of court resources inside outside entities, and then finally the necessity of cell phone use in courts once e-filing becomes mandatory for all litigants. Starting with the exemption standards, to start, in a system that's truly accessible for self-represented litigants, we would expect relatively few exemption requests. We would expect most people would rather file from their house than to go down to the courthouse and file. But for people who need it, we want to make sure that this court rule facilitates an even application of exemption requests statewide. I have visited at least 4 courts that are currently e-filing in some capacity. In some courts, for some cases, it's already mandatory. And when I asked about the kinds of cases that would or would not get exemptions in each court, there was significant variability from court to court, applying what is essentially the same administrative order. So providing specific factors to consider would go a long way towards standardizing who can get an exemption, and in signaling to litigants who is eligible to ask for an exemption. Moving to issues with placing resources for self-represented litigants partly or entirely in outside entities, we generally don't object to spreading resources across a community. We realize that there may be one courthouse in a county that might not be close to people, but we want to make sure that courts don't unintentionally decrease access to e-filing by placing resources in outside entities. It's easy to forget about something that you're not interacting with regularly. You're not going to be paying attention to staffing changes that might necessitate additional training. So we want to make sure that AO considers not just a startup plan, but sustained engagement between the courts and that outside entity to provide continued services to make sure that people have continued access to assistance once e-filing becomes mandatory. And finally, cell phone use. I know this issue is going to come up again because there's the new proposed rule, but as it relates to e-filing, in short, by mandating e-filing while continuing to bar cell phones in many courts, the courts would essentially be telling users that they must have regular, convenient access to a device with email and internet access, while simultaneously telling them that they cannot have their regular, convenient email access inside the court, and any model access plan should address this incongruity.
Thank you very much.
Thank you.
Next, we have Catherine Hennessy from the State Bar.
Good morning, Justices. My name is Katie Hennessy, and I am Public Policy Counsel for the State Bar of Michigan. The State Bar appreciates the court's continued efforts to implement a statewide e-filing system and appreciates the opportunity to provide comments as the court develops its court rules to implement that system. And we hope that our comments have been and continue to be helpful to the court. The administrative order and court rule under consideration today recognize 2 vital aspects to Michigan's e-filing system: that the e-filing system should be accessible to as many litigants as possible, including pro se litigants, but there are going to be circumstances in which exceptions to e-filing need to be made. The workstation calculator referenced in the administrative order indicates that there may be circumstances in which a court can mandate e-filing, but not require an e-filing workstation in the courthouse. The State Bar believes that if courts are mandating e-filing, they should have a workstation housed in their courthouse. And this is because litigants are used to filing court documents at court. The clerks have not only the ability to assist with e-filing, but also to assist with the more general filing questions that litigants have. And finally, this allows the court to directly monitor the workstations and the e-filing assistance that's being provided, and to make adjustments to the instructional materials and their e-filing access plans. And then moving on to the amendments to proposed Rule 1.109, this recognizes that certain individuals may need to be exempt from the e-filing requirement, but it does not define factors that courts should consider in determining whether a litigant has established good cause. Now, the State Bar has proposed a number of factors that we believe courts should consider, and many of those factors align with the factors suggested by Michigan Legal Help. However, I did want to talk about 3 factors that we listed just to clarify an issue. We list in subparts B through D, considering distance to travel to a public computer, barriers to travel, and safety concerns. We believe these were intended to only come into place when a person does not have regular access to a computer or the internet so that they can e-file remotely, and that in this circumstance, these factors do provide significant hurdles to litigants being able to effectively e-file, because not only are they going to have to go to an e-filing workstation to file documents, but they're going to have to regularly check their email on a public computer to see if opposing counsel has filed anything or if the court has issued an order. But the flip side of this, of course, demonstrates one of the great advantages to e-filing. When litigants do have reliable access to computers and the internet and do not need assistance with e-filing, then they don't have to worry about these travel or safety concerns and can file in the safety of their own home or anywhere else in the world. Thank you very much.
Thank you very much. Well timed. We will move on to item number 2, in which we consider proposed amendments to a number of rules to regulate the way restitution orders are entered, modified, and appealed in criminal cases. And we have one speaker, William Valencourt, the Livingston County Prosecutor.
Good morning. May it please the court, William Valencourt. I'm the Livingston County Prosecutor and also the President-elect of the Prosecuting Attorneys Association of Michigan. Appreciate the opportunity to appear today. Pam has filed a comment proposing some minor changes to proposed new rule 6.430. I won't reiterate those comments here, but one thing that was new in some of the other comments is we would support the suggestions by the Michigan District Judges Association and joined by the State Bar that where restitution is unknown at the time of sentencing, restitution could be determined within 30 days of sentencing. That's an appropriate proposal and reflect the reality that, especially in district court, restitution might not be known at sentencing. That would be preferable to simply deleting the restitution requirement as suggested by SATO. I take any questions?
I see none. Thank you very much.
Thank you.
Next is item number 5, where we're going to consider a proposed addition of a new rule regarding the alternative dispute resolution process within the Friend of the Court. And we have Sean Bloom from the Family Law Section of the State Bar.
Good morning, Your Honors. Thank you for having us. As stated, my name is Sean Bloom. I'm with the Family Law Section, speaking on behalf of the council. We have specifically regarding the ADR process, ADM 2018-13. The Family Law Council has discussed at length this proposed amendment, and while council is supportive of the concept of Friend of the Court ADR, we oppose the rule as drafted unless some concerns are addressed. The overarching concerns are that the parties remain adequately represented throughout the process and that they are protected. And we identified 4 specific issues regarding those concerns. One is that attorneys must have the ability to be present and participate in the process throughout. Another is that there needs to be sufficient domestic violence screening, training, and protocols contained in the rule, that the confidentiality provisions should be consistent in the new rule, as there are different confidentiality mandates depending on the specific type of meeting that parties are present at, and that the language regarding an automatic order, and this was one that was hotly discussed, that the regarding an automatic order being generated should be stricken from the new rule. Just in brief detail, while the attorneys are technically allowed to be present, speaking to the first issue, at these conciliation conferences and mediations, it has been the experience of many practicing attorneys that the attorneys present is not just frowned upon, but actually discouraged at some of these meetings. The examples given range from attorneys being asked to sit in the hallway outside the conference room to attorneys being allowed in the conference room, but directed not to speak. And as an example of that, I heard from one of the actual co-chairs of the Court Rules Committee that she recently received a notification from a court of a conciliation conference, and the notification stated specifically, attorneys must be present but must remain in the waiting room. And so this is, and I think this was stated in an earlier, this is the concern over different, without specific direction, different application throughout different counties. Additionally, the proposed rule is written, moving to the second issue, addresses domestic violence and, among other things, references the use of a screening protocol. However, the aspect of the rule is general and discretionary in its application, with the discretion being left in the hands of friend of the court employees. So the other issues are outlined in our written materials. But I would say one last sentence is, that language regarding an automatic order was a very serious concern, that people show up to these and an order can be generated whether their attorneys are present and without their full understanding, and the rules need to be consistent with that.
Thank you very much. Thank you. Next, we have item number 6, the proposed amendment of various rules relating to civil discovery as recommended by the State Bar. And our first speaker is James Harrington from the American Academy of Matrimonial Lawyers.
Good morning, Your Honors. James Harrington. I'm representing the Michigan chapter of the American Academy of Matrimonial Lawyers this morning. But I will first say, as an individual practitioner, I absolutely concur with Brother Bloom regarding the presence of attorneys at conciliation hearings. We should not be made to sit in the hall like second-class citizens. Regarding the discovery court rule proposals, the American Academy has followed very closely all of the proposals. We commend Dan Quick, Matt Kobliska, the scores of other members of the committee. We support proportionality. We absolutely support 35 interrogatory limit in family law cases. The issues in family law cases can be extremely complex, and we believe the 35 interrogatory court rule or limit is appropriate. The reason why I am here this morning is I have a concern over the language regarding limiting interrogatories and the discrete subpart language. Discrete subparts is a term of art derived from the federal courts. When I Googled Michigan cases, there are no Michigan cases on discrete subparts. My concern is that our trial courts may not understand what discrete subparts mean. And I have suggested and would recommend either in the comments or in the court rule itself that language make clear that a discrete subpart is an interrogatory or a subpart not reasonably related to the principal interrogatory. My concern is we'll have 2 or 3 years of appellate court cases come up to the Court of Appeals or the Supreme Court because trial courts think that discrete subparts means all subparts, and it means the exact opposite. The Academy's recommendation is that the language be along the lines of, if a subpart is not substantially related to the principal question, it counts as a separate interrogatory. That can be in the comments, it can be in the court rule. I am proposing and urging the Supreme Court to make it clear now what the meaning of discrete subparts means. There's a footnote in the committee report referencing federal cases That's how I learned what a discrete subpart is, but I don't think our practitioners and judges are going to be up to speed unless we help them out with some clarifying language, either in the court rule or the comments. Any questions?
Thank you, that's helpful.
Thank you.
Next is Dan Quick from the Civil Discovery Committee of the State Bar. And Mr. Quick, we want to thank you for all of the work that you all did on the front end of this to reduce our workload. So we appreciate that.
Thank you, Chief Justice. May it please the court, Daniel Quick. Obviously, we did submit a detailed report that gives the history and the reasons for the recommendations. Clearly, for some time, there's been a realization and a recognition that the course of discovery in civil cases is a problem. It's an access to justice problem, and it's an access to the courts problem, and it's a problem for the efficient administration of justice. And I would urge the justices to take a moment, if you haven't already, to review some of the underlying studies that are cited in the report from the Center of Chief Justices, from the National Center of State Courts, from the Institute for the Advancement of the American Legal System, and others that really detail this problem. 1985 is a long time ago. Frankly, I'm pretty fond of 1985. It was a good year, but it's a long time for there to have not been a holistic review of a major portion of the court rules in those 33 years. The goals here, the through lines, if you will, really are case management and proportionality, and an increased emphasis on asking counsel to cooperate and get ahead of issues to make the process more efficient. We also did put a new coat of paint on a few issues, particularly the subpoena rules and third-party practice issues. And then we did try to come up with a few innovative ideas, ESI Discovery Conference, the representative deposition objection concept, which puts us ahead of the federal rules, are two that I would note. We do have committee members here to address some of the specific niche areas of the court rules. I just wanted to respond to 3 points that came up in some of the public comments. The first is the initial mandatory disclosure rule. This, when it first was adopted in the federal practice some time ago now, also drew some concern and criticism, most of which fizzled. Once it actually came into practice, there really weren't many issues. And in fact, the proposal we've made is trying to improve upon that process. The key with that is that the parties can always opt out of it. If they don't think it makes sense for them in that particular case, they can opt out or ask, or one party can ask the court to let them out. It's also limited to reasonably available information, and the duty to supplement is not some sort of a gotcha. It's only if the information is not otherwise already out there in the case and is material. Similarly, the sanctions that correspond to that is not a gotcha. It's no sanctions are permitted unless it's substantially justified or if there's a harmlessness exception. Secondly, the presumptive number of interrogatories has drawn some attention. Again, this has worked well in federal practice, and we actually have pretty broad support from that among the stakeholder groups we spoke to. And lastly, on the concept of district court discovery, frankly, we just didn't deal with that issue. It's a separate issue with a separate set of concerns as to whether that door should be open, and we didn't. I would just urge the court to, if the proposal is adopted, to work with us, and we'd be happy to work with the court on education for both the judiciary and the bar, whether it's video on demand, whether it's webinars, whatever it takes to acclimate people before the rules go into effect.
So you're willing to do that next phase of the work? Is that what I hear?
Yes, that was volunteering, yes.
All right. And will part of that be teaching judges and lawyers what a discrete subpart is?
Yeah. So Mr. Harrington and I spent some time on the phone throughout this process, and you know, we erred on the side of just borrowing the federal phrase, hoping to pick it up because it has developed to a point of clarity, I think. But whether it's in the comment or whether they wanted to get out ahead of it and actually build it into the rule, I think it's a fine suggestion.
Thank you very much, Mr. Frick.
Thank you.
We look forward to working with you going forward. Next is Judge Yates on behalf of the State Bar.
Good morning, Your Honors, and may it please the Court. My name is Christopher Yates. I'm a Circuit Court Judge in Kent County, Michigan, and I run a specialized business docket. I was also a member of the committee, and so was Judge James Alexander from Oakland County. We had experience in the business court either pioneering or piloting many of the innovations that are included in these proposed rules, and so we've had a fair bit of experience with them. I would like to focus on 4 major changes and explain why I think each one is essential. The first one is the increase in discretion in the sanction provisions. The current sanction provisions weight heavily the awards of attorney fees as sanctions, and we would prefer as judges to be able to tailor the sanctions to the violation. So, for example, the ability to shift the burden of proof if the plaintiff has all the information and won't turn it over, or the ability to disqualify a witness from testifying, I think are all essential tools that we would prefer to have than merely simply to award attorney fees for discovery violations. Second, with regard to proportionality, that's a welcome innovation. I don't think I need to say anything more about that. We in the business courts have tried to fashion discovery plans that meet the needs and the economics of the case, and I think that's been quite successful, and I'd like to see it done across the board. Third, I appreciate that there's much more attention being paid to electronic discovery in the proposals. Whether we like it or not, electronic discovery is here to stay. It's a fact of life, and it's tremendously complicated. I've had several cases where we've moved beyond what one would describe as word searches to do much more sophisticated searching. And so I know one of the comments referred to defining the word search terms. That rules out the more sophisticated computer-aided searches, and so I'd prefer that that not be included. The final concept is the mandatory initial disclosures. Winston Churchill said of democracy that it's the worst form of government except for every other one that's been tried. And that's where I come down on initial disclosures. It's not ideal. There are lots of reasons to complain about initial disclosures, but I think they're far better than the current system where everything has to be directly requested in order to be obtained. So in sum, I wholeheartedly support these proposals. I recognize that there could be some sandpapering done, but I think as a whole, it's a fine product, and I don't say that out of any pride of authorship. I say that out of experience, having worked with these concepts or seen them in operation. So thank you very much for considering this very extensive proposal.
Thank you very much, Judge.
Thank you.
Next, we have David Christensen on behalf of the State Bar.
Thank you. Good morning, Justices. I appreciate the opportunity to speak on this proposal. And I was a member of the committee and the chair of the subcommittee that developed the changes in the discovery rules. And also on that committee, we had judges, commercial litigators, trial lawyers, defense attorneys, poverty law attorneys, really good representation of the spectrum of practice that deal with these rules on a daily basis. And some of these, particularly the initial disclosures, were borrowed in large part certainly from the federal model, but from Judge Popke's Wayne County scheduling order, which required in the hordes of no-fault cases that she deals with and that bench deals with, initial disclosures along the same lines as what are proposed here. Works extremely well. I've had the opportunity to look at other states that have developed changes just like this and have had some time to live with them and report statistics. And even though from the intuitive sense that I have, because in working in this injury and no-fault world as I do, the typical timeline of a case gets pushed way out because the most essential, basic information isn't provided for months and months. You file a suit, it's served, an answer comes, probably an extension was given, interrogatories are served, probably not answered in 30 days, maybe 60 days, then no medical authorizations were provided. Now you're 4 or 5 months out and somebody's going and asking for an extension or an adjournment of dates from the court. And this is the rule, it's not the exception. You take the tens of thousands of cases that are in court and you see these cases growing in length, 3 months, 6 months, routinely, because nobody is pressed and has to produce the information up front, even though we should, and the rules say we should. In real practice, it doesn't. This will shift right up front, stuff we know we're going to have to do. We're going to have to give you medical record releases. let's do it now so we don't have these adjournments. That's one. Case management, that's going to make the courts work better. It's going to save a lot of money and save a lot of time for litigants. And I don't need to touch on the other proposals particularly because they all fit in and follow from initial disclosures. You don't need as many interrogatories. The limits on depositions are very reasonable. We've lived with those in the federal system. But the best thing is you can opt out. The rules have been, are the same for a $25,000 case as they are for a $200 million case, and these present a right sizing, I think.
Can I
for
ask a
most of
question about the end of discovery?
Yes.
Under the proposed changes, is it the idea that, under the current system, my understanding is as long as you initiate discovery before the discovery deadline, it's considered timely,
Yes.
the request. Is the idea to change that to a regime where you have to initiate it in enough time for the other party to have the time under the rules that they're given for a response before the completion date, or is that not something that was under your committee's jurisdiction?
Well, so let me answer what I understand the rule to be, and I could be wrong because I believe you have to initiate it, but I don't believe it has to be, for example, 30 days before the cutoff for an interrogatory answer. I believe it has to be initiated in a timely enough fashion that the other side can begin to respond to it.
So it doesn't, we're not trying to figure out if a subpoena, for example, gives 14 days, that has to be done, 15 days before the completion date, or if you have 28 days to respond to, I don't know what all, I should know, I can't remember.
So we didn't deal with the subpoena issue in my committee, and I know it was significantly reworked in this proposal. I wish I could give you a clear answer on that, but I can't. I'm sorry. I do second the nomination of Mr. Quick to head up the training of the bench, but I'll help work. Thank you.
Thank you. Next is Matthew Kobliska, also on behalf of the State Bar.
May it please the court, Matthew Kobliska appearing on behalf of the Discovery Reform Committee. My practice is limited to divorce and family law matters and mediation, and my comments will be directed to that area. We often say that one thing that differentiates family law cases from general civil cases is that real people pay our fees. Dan Quick talked about access to justice, and I can think of no greater area than the family law area where that needs to be addressed. We need to root out inefficiencies wherever they may be found. And it's a difficult task in family law cases, well, in any general civil case, because you have the countervailing principles of efficiency and fair and equitable disposition between the parties and best interests of minor children. But I think that the Reform Committee's proposal strikes that balance. There are a couple of areas where there are separate family law rules relating to discovery, and I think there's a recognition that in domestic cases that they're kind of a different breed entirely that warrants some change from the general civil rules, and I could go through a laundry list of reasons as to why that is. But I'll mention that in a typical divorce case, you could have 9 or more categories of issues, each of which have different evidentiary proofs. For instance, child support, spouse support, they may seem like they would require the same information, but they don't. In child support, we've got a family formula that applies, and we have certain bases for deviation. In a spouse support case, we've got the 14 Olson v. Olson factors. So even two things that seem alike really aren't. In a case involving a family-held business, it could require as much discovery as a single shareholder oppression or corporate dissolution case. So again, I could go through a laundry list here, but I want to make the best use of the time that I have available. And one thing that I did want to talk about was the proposed 3-point XXX rule, which is keeping purely private matters out of court. What we've done as practitioners, responsible practitioners, is often whenever we have a sensitive document, whether it's a personal tax return, God knows nobody wants their tax returns made public. When we have those situations, we might append it to the judge's copy of the brief and also opposing counsel's copy of the brief, but not include it in the public court file. There are problems with this, one of which is there's simply no basis in the court rules to do so. It does not become part of the public record on appeal. And of course, with the advent of e-filing, it's going to eliminate the judge's brief altogether. So we had hoped to address that issue of purely personal documents. In the proposal as written, there's an under seal mechanism under 3.xxxb, but there's been some, I think, back channel discussion since then that would indicate maybe that's not the best tool to accomplish that. Rule 8.119, I think, has a process in which there needs to be a motion and some other things, which I think make it very cumbersome to use. I think, and many people think, that the best method would be to employ a two-file system as is used in juvenile court, specifically MCR 3.903A3, where there's a separate social or confidential file, and then there's a public file. Many family court judges employ this two-file procedure as it is already. So I think rather than have the under seal requirement, there should be documents marked as confidential, which would simply be kept in a separate court file. So if the court has any questions as to the rationale behind the proposed subchapter 3200 rules, I'd be honored to share my perspective.
I don't see any. Thank you very much.
Thank you for the opportunity to be heard.
Thank you for being here. Next is Joy Gaines on behalf of the State Bar.
Good morning, Your Honor. May it please the court, Joy Gaines. I am a member of the Washtenaw County Public Defender's Office. Along with myself, we had representatives from we had a judge from the juvenile court in Oakland County. We also had an attorney who specialized in working with parents. We had an attorney from the University of Michigan Child Advocacy Law Clinic, where they represent children, parents, and even sometimes the state in child welfare meetings or hearings. In my office, we represent either parents or children in child welfare cases, and we also take representation for delinquency cases. When we were looking at the juvenile court rules, we focused on three major things. The first would be that we wanted to ensure that discovery was automatic, full, and timely. The second is that we wanted to look at the delinquency rules and ensure that youth receive similar protections and as adults. And the last thing we looked at were the termination of parental rights, the court rules dealing with termination of parental rights, because that is such a crucial part of the proceedings. And there weren't really the same body of discovery rules to protect those type of proceedings. So the first thing we did in terms of 3.922 sub A, our recommendation was that the discovery be automatic as opposed to having to be requested. And this court rule applies to both the delinquency and the child welfare proceedings. And we thought it was very important that given the high liberty interest, that discovery be automatic, and also given, in particular in the child welfare cases, that often the Department of Health and Human Services has information that may not even be available to, in our county, it's the prosecutor who's handling those cases, just to really make sure that it became available. It was suggested that I give some examples, and we all had examples of this, but I would say that probably one of the more egregious ones was a hearing in which I participated, and the timelines were very short for the adjudication trial, and it was about a week before, and we were still waiting for the medical discovery, which is a key part of the case. And I was being told that there wasn't medical discovery available yet. They were still waiting for it. But when we were in court, the statement by the petitioner, the department, was that I don't have all of it, and that's very different than not having some of it, having some of it is very different than not having any of it, which is what I was led to believe just about a week before trial, and it was ultimately about 2 to 3 inches thick worth of medical discovery alone, not mentioning their reports. The other thing that, in terms of timeframes at various points, not only through 3.922A, but also when we were addressing the court rules that have to do with the permanency planning hearings and the dispositional review hearings and the post-termination review hearings, we also put in a request or a recommendation that the discovery or the reports that are submitted regularly at these review hearings be submitted 7 days in advance, and also that there be complete information. In our practices, we had all seen where what we received, sometimes the night before, sometimes the morning of, would have a range. Sometimes we'd get everything that we'd really want, the caseworkers' reports, the psychological evaluations, the substance abuse results, but we'd get, again, a very thick packet the morning of, or coming through at 5 o'clock the night before. Other times we might get very timely, or sometimes again the day of, a 2-page report that would not give all the information. One example was that one of the reports said that all of the drug screens had been cleaned, but upon receiving the log, the parent had been required to do random screens that would have been 15 over the reporting period and had only taken 2, all of which had been clean. So we wanted it to be complete and full and timely in that sense. With regard to the delinquency proceedings, the court rule for that had really just been 3.922. So we also incorporated what we thought were the relevant parts of the criminal law discovery rule so that children would receive similar protections. And then the last thing with regard to the termination of parental rights hearings, we, in that court rule, we made reference to and asked and recommended that be included the changes that we had made to 3.922A and also the timelines that we had that we thought were appropriate. So, are there any
Thank you very
questions?
much, Ms. Gaines.
All right, thank you.
Appreciate it. And finally, we have George Strander, also on behalf of the State Bar.
May it please the court, my name is George Strander. I was a member of the committee and also a chair of one of the subcommittees. I'm here to speak on the probate amendment. There's long been a tension between the world of probate court matters, generally involving petitions, a respondent, and often multiple interested persons, perhaps for an estate or the care or treatment of an individual, and that of general civil procedure, which assumes cases with a plaintiff, a summons and complaint, and one or more defendants. Such is the case specifically in the area of discovery. The current rule at 5.131A indicates that the general discovery rules apply in probate proceedings. While this directive is not particularly specific, subchapter 2300 is the one place in the court rules where the rules governing discovery are fully outlined, and these general discovery rules assume cases with a dichotomy of plaintiffs and defendants. General discovery rules assume an adversarial action where distinct parties are seeking information to prepare their cases adequately. Interestingly, matters that are contested to the same degree as a lawsuit can exist in probate proceedings. Examples might include will contests, actions to remove a trustee, or fights over attorney fees. To the litigating interested persons, discovery can be just as important as it is to a plaintiff and defendant in a lawsuit. The question then is how to fashion our rules to fit the general discovery structure to all probate matters, and especially to those actions which display the litigation we expect to need discovery most. The proposed amendment at 5.131 answers this question by first making clear that all discovery tools in subchapter 2300, with the exception of mandatory initial disclosures, are open to any interested person in a probate proceeding. The proposal goes on to carve out a specific minority of probate actions that require mandatory disclosures under newly proposed 2.302A. The aim is to specify those highly litigious probate proceedings which function much like lawsuits and make the active interested persons make disclosures just as plaintiffs or defendants would have under MCR 2.302A. Under the proposed amendment to 5.131, mandatory initial disclosures are triggered after the filing of an initial petition by either the filing of a demand for such disclosures by an interested person or the judge determining that such disclosures are appropriate after an interested person contests the petition. Disclosures must be made by both petitioner and the demanding or objecting interested person. In this way, we require disclosures when needed and from those who need to provide them. The proposed amendment also provides a mechanism for ordering disclosures from specific interested persons at some point after the initiation of a proceeding, or from those in addition to others already needing to make disclosures. This recognizes that the scope of interested persons' interests may not always be apparent at the time a petition is filed, and that another who may not yet have filed a demand for disclosure or otherwise objected may need to make disclosures.
Thank you very much.
Okay, thank you.
Appreciate it. And our last item is number 7, the proposed amendment to MCR 6.001 to allow for discovery in criminal cases in district court. And our first speaker is Joshua Blanchard.
Good morning, and may it please the court. I think that making MCR 6.201 applicable to misdemeanor cases will increase the cost to accused citizens, will invite error in misdemeanor proceedings, and isn't workable given the current SCAO case management guidelines. Right now, we have misdemeanor cases that are handled fairly expeditiously. If we require criminal defense lawyers to provide reciprocal discovery, produce witness lists, those costs are going to have to be passed on to citizens. Right now, misdemeanors that are generally less serious than felony cases get handled quickly and at less cost than a felony charge. And the other thing that we see is in the district court, more than any other court, we see pro se litigants. In my home county, every time there's a jury pick, I see people picking their own juries and ultimately trying their own cases. And we also see a lot of folks that dabble in misdemeanor criminal cases. We'll see lawyers who don't practice criminal defense regularly showing up. If we have the reciprocal discovery rules, I think we're going to see people missing deadlines. You know, right now, you're required to file a witness list. It can be amended without leave of the court up to 28 days before trial. I think we'll see people blowing that deadline. We'll see pro se litigants who don't know about the requirement. They're going to show up to trial and have their witnesses struck because they didn't comply with the reciprocal discovery rules. That ties in somewhat with the SCAO case management guidelines. Right now, they require pretty quick resolutions. In one of my local counties, at arraignment, they set your trial date, and it's often a little bit more than 30 days out is your first jury trial setting. If it actually goes at that time, you'll have a week or less to investigate the case and provide the notices unless you're able to file a motion and obtain leave of the court to notice witnesses inside of 28 days. And so if the court's going to impose reciprocal discovery in misdemeanors, I think we also then need to extend out the case management deadlines. So I think the solution is to either make MCR 6.201 be applicable to misdemeanors. That's the requirement that prosecutors disclose really the stuff that's in their file generally. I think that's one solution. If the court doesn't like that, a second solution is to track Federal Rule 16, which conditions a defendant's obligation to provide reciprocal discovery on him first making a demand, so that someone could either make a tactical decision not to demand discovery, or if somebody doesn't know about that obligation, a pro se defendant, and doesn't request it, then they're not penalized for not also providing it. So I think one of those solutions would make it workable, and I'd ask the court to do one of those things.
And is it your view that one of those solutions would be better than doing nothing? If our choices are do nothing, do what we've proposed, or take one of your middle ground options,
Yeah,
do you have a ranking?
I would prefer to see 6.201B made applicable so that prosecutors have an obligation to turn over essentially the stuff they have.
Thank you.
Thank you.
Next is John Shea.
Good morning. Thank you. Although I disagree with my brother counsel Josh Blanchard's opposition to the proposal, I think that we're largely on the same page with respect to what a proper solution might be. I want to start by saying first, misdemeanor cases are necessary, and I've read all of the letters that were submitted to the court in connection with this proposal, and frankly, I'm a little impatient with the positions of some that these are petty offense cases where we don't need to take them seriously. The heartland of misdemeanor cases in all the courts that I practice in are domestic violence cases, stalking cases, aggravated assault, malicious destruction of property, drunk driving, retail fraud, civil infraction causing death, civil infraction causing serious injury. These are serious cases. Those are the bulk of the cases. You sample randomly any 3 district court judges in the state, and they're going to tell you the bulk of their cases aren't animal at large, noise violations, or blight tickets. They are the ones I have just described. They're serious cases with serious consequences for people, not just jail, driver's license sanctions, professional license sanctions, immigration sanctions, loss of housing sanctions oftentimes, loss of gun rights, loss of hunting and fishing rights. These cases involve, if a person is convicted improperly or convicted of something more than what they should have been convicted of, oftentimes create life-changing outcomes for the defendant. So these are important cases, and that's one of the reasons why a rule is necessary. These cases are oftentimes not simple. Ask any drunk driving lawyer how complicated a drunk driving case may be. Any lawyer who's ever tried a domestic violence case, how complicated that kind of a case may be. They're not simple, oftentimes. And discovery is essential regardless of whether you're going to go to trial in those less than 5% of cases, or you're going to negotiate a plea. Because whether you're a civil lawyer or a criminal defense attorney or someone who does both, you recognize that how you negotiate a case depends on what the case is about. And if you don't have discovery, you can't honestly say you know what the case is about. There is no uniform rule across the state. It's a patchwork response by district court judges. I think that's one of the reasons why the MDJA supports this. They'd like to see some uniformity.
Mr. Shea, what's your response to what we do about the pro ses? I mean, how do we handle, or the number of cases in district court which really are resolved by quick pleas, where that makes sense, the MIPs and the other dockets.
Yeah.
Do we bring the system to a crushing halt?
No, I don't think so. I like Mr. Blanchard's proposal that I'm sure the prosecutors wouldn't like the 6.201B option, but I like Mr. Blanchard's proposal that there be an opt-in. If a defendant or a defense counsel does not want discovery, then they don't have to provide it either. That is the Rule 16 federal rule. It seems to work well there, and I think that would work well here. I think it would take care of many of the cases that Your Honor has just asked me about, the pro pers or the people who want the quick plea. You go to your first pretrial and the prosecutor offers to drop it to a civil infraction if and so I think that's an easy fix. On the pro pers who want to litigate their cases, that's a problem. It is a problem, but I think we do it in small claims. We have information sheets where we tell pro se litigants how it is you can prosecute a small claims action. We do it in many courts when it comes to pro pers who are prosecuting or seeking personal protection orders. I think there's certainly ways that we can do that. More importantly, and I've said this before, including in this court, I don't think the rule should be drafted to accommodate the minority of cases. I think the rule has to be drafted to accommodate the heartland of cases, and the heartland of cases are not pro pers. So I don't want the perfect to be the enemy of the good. My time is up.
But I interrupted you, so if you have any other important thing to tell us.
I'd like to say that reciprocity, I think, is kind of a false evil that's set up by some of the people who have commented on this. We deal with reciprocal obligations in felony cases. We do it in the federal system. Again, most of us who do criminal defense work are familiar with what that is, and frankly, I don't think it's all that hard. I don't find it to be unduly burdensome to have to give prosecutors in felony cases discovery when they request it. And finally...
Mr. Shea, can I
yes,
ask you one?
Yes, sir. Yes, sir.
Can I ask you one question, please? I think you've been very articulate in communicating how important these cases are and making the point that these are not insubstantial or insignificant cases. Point well taken. However, how have we muddled along for so many years without lawyers, in your words, knowing what their case was about?
I am fortunate to practice in Southeast Michigan. You know, Washtenaw, Western Wayne, Livingston, Jackson, a little bit of Lenawee, a little bit of Monroe. In the counties where I practice, prosecutors historically have had an open file policy in misdemeanor cases. But it's been a courtesy. It's been at their largesse. And I don't think that that's a good way to run a railroad. There are other parts of the state where that doesn't occur, and where I think it is more difficult, and attorneys have to utilize stopgap measures. They have to use the Freedom of Information Act where it may apply, and there's lots of problems with that. For one thing, it's not enforceable in the criminal case itself if the municipality or the local unit of government doesn't respond. Or they rely on private investigators, which can be expensive. Or they rely on the attorney doing his or her own investigation, which can be incomplete. It's just not fair. So we muddle along. I think that's a good way of saying it. We muddle along, and let's remember, what do our statistics tell us? 2 to 3% of cases go to trial. So, you know, it usually don't see the problems because they don't get tried, they don't get appealed, and so nobody sees the problems. And one of the problems, I believe, if you look at exonerations, for instance, if you look at people who run Innocence Project, they identify 3 primary areas why convictions are either overturned as unlawful or the penalty was excessive. One is bad science, another is bad eyewitness identification, and a third is defendants not getting a full batch of investigation, including discovery, conducted by defense counsel, and somebody going back after the fact and redoing the investigation and finding things that should have been found in the first place. If there's a discovery obligation on prosecutors, then that takes away, I think, a good portion of that in an area where we have been silent on it for too long. I don't think the Michigan Supreme Court has spoken on misdemeanor discovery ever. We've relied on cases like In re Bay County Prosecutor and others like it, and general custom and practice. I think, and I want to say, I think enlightened prosecutors provide discovery for a good reason. When my client looks at the drunk driving video that we got from the police officer's patrol car and sees himself tottering all over the road, he all of a sudden isn't quite so sure that he passed those field sobriety tests. And it makes for a better outcome for everybody. So I think that it's efficient. I think it is fair, and I think that the cases are too serious these days for us.
So do you disagree with what seems to be the premise of those who disagree with you, that this is going to result, your position is going to result in a lengthier and costlier process, or is your view just that will result, but that's just part of the cost of a fair justice system?
It's a fair, very fair question. There are costs in any rule, no matter what rules there are consequences to the rules, and oftentimes it can make things more complicated, and it can delay things. I agree entirely with Mr. Blanchard's observation that the SCAO guidelines when it comes to misdemeanor cases will need to be modified in some fashion so as not to set up defense attorneys to fail who do have reciprocal discovery response obligations. And that will entail some lengthening of misdemeanor dockets in courts that have those fast-paced dockets. I don't practice in many of those kinds of courts, Mr. Justice Markman. It's not uncommon where a case is going to be litigated, a misdemeanor case is going to be litigated where we litigate them for it to take 6-9 months for a case to come to trial, which already is outside of those SCAO guidelines typically. So I don't think it's going to make any difference where I am. I think in cases that have more fast-paced dockets, like the one that Mr. Blanchard described, it is going to require some adjustments.
Well, to put the same question to you that the Chief Justice just put to Mr. Blanchard, do you see any merit in some of the middle-of-the-road propositions that he's laid out to the court here?
I do, and as I said earlier, I like the opt-in option, where it's not. The prosecutor doesn't have to provide it unless it's requested. The defendant does not have to reciprocate unless the defendant requests it. If the defendant wants to rely on his or own means to investigate the case and not seek discovery from the prosecutor, then I think that's a fair middle ground. And there are some competent, good misdemeanor defense attorneys who have operated that way for a long time and really don't want to change. I don't see a problem with that because I think they still do a good job. But I think that there should be a uniform rule for discovery where defendants and defense counsel feel that they need it.
Thank you.
Thank you.
Next is Stuart Friedman.
Good morning, Your Honors. I'm going to dispense with my prepared remarks because I think much of the territory has already been covered by my brother counsels. If forced to choose between the two compromise options that have been proposed, I would opt for copying the federal opt-in proposal. With respect to the discussions about pro se witnesses, I would commend for the court's attention California Judicial Court Form FL 321, which is a witness list exhibit form that specifically was tailored for pro se litigants. I would note, as other counsel have stated, that the consequences of a modern misdemeanor conviction are far greater than they used to be. I have a client I just won in the Board of Immigration Appeals. While he's been deported to Albania, he was removed for 2 different offenses involving small personal amounts of marijuana. So the consequences of the collateral effects of these convictions can often outweigh the actual conviction. I would also point out that we do not have provisions in our current court rules for motions for a new trial or motions to withdraw pleas in these misdemeanor cases. So it's sort of difficult to determine actually how much damage has been done, because you have to go through a very tortured route to get these facts in the record in some courts. I know later this term, this court's going to be dealing with a mess I may have created about whether or not we have a writ of quorum nobis, and it was out of one of those cases that originally conceived that issue. I do think we have a problem. I note in closing that 50 years ago in People versus Wimberley, we stated that the policy in Michigan was not to have dueling legal gladiators, but to have broad discovery, because trials were supposed to be a search for the truth. I find it puzzling that we're still having this discussion literally 49 years after the court wrote that. Thank you.
Thank you. And finally, we welcome Prosecutor Valancourt back to the podium.
Good morning, William Valancourt, prosecuting attorney from Livingston County. Pam supports the concept of a court rule regarding discovery in misdemeanor cases, but we think the application of the felony discovery rule is too broad in light of the nature and volume of cases in district court, as well as the shorter time frames involved for disposition of these cases. The staff comment points out that, quote, full-blown discovery for misdemeanors would be the default, with the district court having the discretion to order limits. The reality of that position is that it would effectively be full-blown discovery in every case. We'd suggest that it's more appropriate to flip it, make more targeted discovery as a default, but the district court would have the ultimate authority to order broader discovery in appropriate cases. It could be flexible to handle the different nature of the broad variety of cases that come to the district court. So our proposal is to adopt something that was based on a proposal a number of years ago from the Committee on the Rules of Criminal Procedure that this court appointed in 2002. Instead of a one-size-fits-all approach to discovery, it would be more right-sized that reflects the practical differences between felonies and misdemeanors. A no-ops on person or a driving while license suspended case is dramatically different from a CSC or an assault murder case.
Mr. Valancourt, I appreciated that, learning about that prior proposal, because I didn't know about it. And I appreciated Pam bringing it to our attention. Do you have a view as to that proposal versus some of the other middle ground proposals that have been talked about in the courtroom today?
Well, I know that we've heard from our friends on the defense a bit of a disagreement about reciprocal discovery. If you look at the rule that's proposed by us, the only duty imposed on a defendant is to disclose witnesses. None of the other duties imposed by 6201 would apply under our proposal. And for prosecutors, that's especially important to avoid trial by ambush, because especially where experts are concerned. Currently, there is no requirement anywhere for a defendant to disclose an expert. So the first time the prosecutor might know there's an expert is when they show up for trial. That would include experts in drunk driving cases where you're dealing with issues of retrograde extrapolation, or accident reconstruction experts in moving violation causing death or serious injury. So disclosing witnesses really is not a burdensome requirement. And I think our proposal...
But I didn't hear Mr. Shea or Mr. Friedman necessarily to disagree about reciprocal discovery. I guess I'm more curious, how do you feel about the Federal Rule 16, opt-in, opt-out?
I mean, I will confess I'm not familiar with the federal rule. I know the reality is that every defense attorney on a case is going to ask at some point to either see the police report, even if it's just to verify it's a suspended case, I want to see what the basis for the stop was, or they're going to want a copy of the report. And as a matter of practice, as Mr. Shea pointed out, there is a benefit for us in giving discovery because we show the defendants, hey, we've got a good case here. And so I think opt-in, opt-out, I don't think is necessarily the answer. I think doing something really targeted where it essentially is, it says if the defendant asks, the prosecutor has to give these things. The only requirement on the defendant is to identify witnesses. And if there's an attorney involved, that's usually pretty easy. Yeah, we're calling an expert, it's so-and-so. Or at the final status conference, when you're starting jury selection, the judge can say, does the defense have any witnesses so we can identify it for the jury? So our rule really, is...
I think your rule sounds like opt-in, opt-out, but maybe even more tailored. But
yes.
I just was, okay. Thank you.
Just one final observation. Generally, discovery in misdemeanor cases really isn't a problem. Police reports and lab reports are routinely provided expeditiously. And if there are discovery issues, they're either resolved by the parties. Rarely is judicial intervention required. So thank you.
Thank you very much. That concludes the hearing. We appreciate you all being here.